Under what circumstances are the police authorized to stop an individual, find drugs on them, and then arrest them for it? To find out, you have to read People versus Johnson, but it's 35 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Johnson. The citation for this case is 2023 New York Slip Opinion 02734, published by the New York Court of Appeals on May 18th of 2023. This is a DeBoer analysis. This is an analysis of whether the police had sufficient authority to interfere with the civilian the way they did, where the police justified in stopping, frisking the defendant, and thereafter recovering drugs. To understand and appreciate how this case fits in and to analyze it, you have to understand that briefly in the 1970s, there was a landmark case called DeBoer, People versus DeBoer, D-E-B-O-U-R, that set out the criterion to analyze how police can interact with the public. And they basically set out 4 levels of interaction the police can have with civilians. And if they exceed the authority that they have, then whatever they recover is subject to suppression as what's called fruit of the poisonous tree. So if they walk over to you and they think you have a gun, but for no reason, just a hunch, and they grab you and throw you against a wall and take the gun from your back pocket, they didn't have the authority to do that. So even though they got the gun, that would be fruit of the poisonous tree and is subject to suppression at a trial. Okay, so what are the 4 levels? The 4 levels are level 1, request for information. For the police to request information, they need, and this is the key word that's attached to it, an objective, credible reason, not necessarily indicative of criminal activity. So, request for information, objective, credible reason. Number 2, level 2 is common law right of inquiry. So they can ask questions that are a little bit more pointed about whether the individual has done something wrong. Do you have a gun? Do you have any drugs on you? For that, they need founded suspicion that criminal activity is afoot. Founded suspicion that criminal activity is afoot. Level 3, forcible stop. So for the police to forcibly stop someone and detain them and thereafter frisk them, that's a level 3 interaction. They need reasonable suspicion that the particular person has committed or is about to commit a crime, or that person is armed and dangerous. That's for stop and frisk, level 3. And level 4 is arrest and custody. To arrest somebody and put them in custody, they need probable cause to believe that the person has committed a crime or an offense in their presence. That's the 4 levels. So what's the case? What are the facts of this case? The facts are, in April 2015, there's 2 police officers and a uniformed police officers in a marked police car doing a patrol around a high crime area in Rochester, New York. They come across a Ford Explorer with a driver in the driver's seat. This is the defendant. He's in a legally parked spot, no problems with it. And they see that he moves from the driver's seat to the passenger seat. And then he leans over with his torso and pulls something, reaches towards the driver's seat again. And they then turn the overhead light on. They're watching this. They then exit their car while he exits his car. And they approach him and they say, "Hey, stop, stop." They say, "Hold up," but the defendant keeps walking away. Officer Pike, who's one of the officers, then catches up to him and asks him if the defendant's nervous. And the defendant says no. The officer then says to the defendant, "Do you have any weapons on you?" And the defendant says, quote, he says the word "nothing." "I have nothing on me." The officer then frisks him, finds no weapons, but feels what he feels like bags of drugs maybe. He asks the defendant what's in his pockets. The defendant says the word "nothing." The defendant then begins emptying his pockets, throws 2 bags of marijuana on the floor, and in his fist he has a bag of what's believed to be heroin. Officer Pike arrests the defendant for the possession of the drugs. It goes to a MAP hearing at the trial, and he moves to suppress. And the officer testifies, "I was suspicious. I had a feeling he was doing something wrong. It all seemed very uncommon to me." It's all not suppressed. The defendant's convicted of those crimes. He appeals, and the appellate division affirms what the trial judge does. It goes to the Court of Appeals. And here's what we have the holding here. It's interesting because we have 2 different holdings. We have the majority holding, and we have a really strong concurrence, a really fascinating concurrence from Judge Rivera. The majority holding says, forget about level 1 and level 2 analysis. Let's go right to level 3. The problem here is that they stopped and frisked the defendant here without authority. Police Officer Pike did not have a reasonable view the defendant was armed or that he committed or was about to commit a crime when he stopped the defendant and frisked him for the gun. All Pike knew was that the defendant moved from the driver's seat to the passenger seat. He moved his torso back to the driver's seat. He was pulling up his pants and trying to buckle his belt, and he appeared nervous. That is not sufficient, and therefore the officer did not have the authority. He exceeded his authority in doing a stop and frisk. Therefore, evidence suppressed, conviction reversed. But the concurrence here is really interesting because Judge Rivera says the majority's wrong with how they. Rivera says the majority's right. This exceeded the authority, but Judge Rivera says they did this the wrong way. They have to look at every single level. Don't just skip to level 3 and say that was wrong, because that risks legitimizing the level 1 and level 2 violations. Here, she says, level 1 was violated, level 2 was violated, level 3, and level 4. Why? Because when police officer approached the defendant and asked questions after the defendant just got out of the car, there was no objective, credible reason. Violation. Then when he asked if the defendant had any weapons on him, which is level 2, that didn't have an objective, credible, that didn't have the founded suspicion that criminal activity was afoot. Then when he frisked for weapons, that was wrong because he didn't have reasonable suspicion that the defendant had committed or was committing an offense or had a weapon. That exceeded level 3. And when he arrested the defendant, okay, there was allegedly heroin, so that maybe was met, but you can't legitimize a higher level by violating lower levels. So the detective's later conduct can't validate the earlier unauthorized encounters. But beyond that, Judge Rivera goes further and she says DeBoer should be thrown out. She says DeBoer is a problem. We've basically created a state where DeBoer allows police to involve and interfere with civilians, even though civilians have a right to be let alone and free from police involvement. She specifically says that we have a right to walk away and we have a right to be left alone from police. And so she would apply level 3 analysis that police should not be able to approach anybody unless they have reasonable cause to believe that a crime has occurred. That's what Judge Rivera would say. Beyond that, the police should just be able to walk around, respond when people approach them, but not interfere with civilians unless they're approached or unless they have level 3 or greater knowledge. And that's the case of People versus Johnson. I encourage anyone to read this case for Judge Rivera's concurrence. It's very interesting. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.